Welcome everybody to today's webinar. I'm Martin Green, I'm the sales manager here at Alps, and I'm joined by Nick Copley, who is our head of claims at Alps, and he'll be walking us through the evolution of RTA injury claims over the past 15 years. So this is the fourth webinar that we've run now, and for those that are new to the format, what we'll do is we'll go through the webinar, we'll cover the topic, and we'll do a bit of a question and answer session at the end. So if anybody does have any questions that they'd like to ask throughout, please just pop them in the chat, and then we'll address as many of those towards the end as we can. So we're calling this Navigating the Minefield because that's exactly what it's become for anybody trying to bring a claim today. So firstly, Nick, can you please give us a quick run through of what we're going to cover?
Yeah, thank you, Martin. So we're going to start off with the landscape prior to 2010 and what led us to all the reforms. Next, we're going to go on to the initial portal, which was introduced in early 2010. Then the extension of that portal and the Legal Aid in Sentencing and Punishment of Offenders Act 2012, which came in 2013. Then the evidence controls that came a little bit later in 2015. Then we'll move on to the big reforms. We'll spend a lot of time on the Civil Liability Act, the Official Injury Claims Portal, and then what led to the mixed injury valuation, where you had a tariff injury and a non-tariff injury. Then the extension of fixed recoverable costs, which were introduced at the same time as LASPO. Then we'll have a quick recap, look at what the current state of play is, the minefield, as you described. Then we'll look at what the takeaways are from that and what we can expect next on the horizon.
Okay, perfect. And so starting with the big picture then, what's changed fundamentally about RTA injury claims since 2010, and sort of why are you calling it a minefield?
Yeah, so well, the transformation's been huge. So at the start of 2010, we had, and prior to that, we had a relatively straightforward but perhaps inefficient system, largely paper-based, which could partly be down to the industry being reluctant to catch up to the available technology at the time. We had hourly rates for legal costs, which, as generally speaking, the claimant would not be paying for their costs up front, and then costs were recovered directly from the compensator at the end of cases. This didn't encourage efficiency. There's not the same pressure as if you've got a fee-paying customer trying to keep your costs down. So moving to today, we're operating multiple parallel systems. We've got different portals, various protocols, fixed tariffs for some injuries, common law valuations for others, a web of cost regimes depending on claim value, injury type, even what type of road user you are. What started as a conventional claims process has evolved into a system where the process you follow, the compensation you might receive, whether you can recover costs, all varies based upon multiple factors. And for someone trying to navigate this without representation, it can feel like trying to cross a minefield.
Okay, so that's quite a transformation there, isn't it? So before we get into the specifics, Nick, can you paint a picture of what RTA claims looked like before 2010, and what was the system that all these reforms were trying to fix?
Yeah, so it was a different world entirely back then. We had no dedicated pre-action protocol for low-value road traffic accident RTA injury claims. All claims followed a general personal injury pre-action protocol before litigation. So there were no fixed stages or deadlines beyond statutory limitation or any deadlines that the parties imposed on each other. Liability would often not be addressed until much later in the process, which inevitably led to long-lasting claims, high litigation rates, and of course, therefore, higher costs.
Okay, so what about the cost structure back then? What was that like?
Okay, so costs were primarily governed by solicitors' hourly rates. There was a predictive cost scheme from 2003, but it only applied to very specific low-value RTA injury cases. So these were cases that settled before court proceedings and where damages were between £1,000 and £10,000. So under this scheme, a claimant could expect to recover £800 costs plus additional costs equivalent to a percentage of the damages that they had successfully recovered from the defendant. So outside of this narrow scheme, Solicitors would bill at hourly rates, recoverable from the defendant if successful, and it could be quite easy to remove cases from that predictive cost scheme as well. Another key difference was that we had recoverable success fees if you were under a conditional fee agreement, and you also had recoverable after the event insurance premiums.
Okay, so what specific problems did the government identify that made reform inevitable?
So the issues included delays, so even straightforward cases go on for months or years. Secondly, and perhaps the biggest reason, is the disproportionate costs. So legal costs would frequently exceed damages in low value cases. Aside from the predictive costs, as discussed, we've got the hourly assessed costs, and you could recover a success fee of 12.5%, or that ballooned to 100% success fee if the case was successful at trial. The result of this, as mentioned, was that in a lot of low value cases, costs would frequently exceed the amount of damages that claimants were receiving. In addition, they could insure their cases and recover the cost of that premium from the compensator at the end of the case. Now, the cost of this premium varied due to different structures of premium, but in some cases, and even on very straightforward cases, these premiums could be over £1,000 if the case concluded at trial. Another issue was inconsistent processes. So there was no standardization in pre-action evidence gathering or sharing or negotiation. And whilst the protocol encouraged sharing of evidence pre-litigation, there was no real way of making this happen, except for expensive pre-action disclosure applications, which again could add to the length of a case. Last, there was a perception of fraud and exaggeration risks in this type of work, possibly not helped by, or the perception was that it was not helped by a referral fee market.
Okay, and sort of looking back, I understand that the market conditions were quite different then too.
Yeah, so we can see the graph there. We had quite high claims volumes, and whiplash was already a major concern for the insurance industry and the government. Perhaps one of the biggest differences, as mentioned in the previous slide, was the referral fee market was booming. Claims management companies, insurers, garages, even brokers were actively selling accident data to law firms for significant fees. The high claims numbers were considered to be heavily contributed to by the referral fee market, increasing claims numbers, and with high cost per claim, this created a spiraling cost situation. It was suggested that this was putting insurance premiums under immense pressure, and created what the insurance industry termed a compensation culture. I've not got the pre-2009 numbers listed here, but just to give you an indication of how claims numbers rose in that period prior to 2009. In 2007, the compensation recovery unit records around 550,000 RTA PIs. That was up from about 207,000 in 2004, and only 110,000 in 2002. So you can see that that's steeply risen over that period. These concerns fed directly into the Jackson report in 2009, which examined the cost of civil litigation, with part of the report focusing on the disproportionate costs in road traffic accident PI claims and the need for reform. So before you ask any more questions, I'll just quickly mention the Jackson report proposed a coherent package of interlocking reforms designed to control the costs and promote access to justice surrounding civil costs more generally, so not just RTA PIs. It proposed many measures, including fixed costs across many areas of civil litigation. It did make reference to RTA PI claims. In particular, there was mention of the upcoming portal, which was in the works at this time, along with tighter controls on medical evidence.
Okay, perfect. So that brings us nicely to the first major reform then, doesn't it? The RTA claims portal in 2010. So what exactly did this system aim to achieve?
So with the portal, there was a specific pre-action protocol. Remember, we didn't have one before. The ministry was explicit in their aims for a portal, which was to deliver a simple, efficient and cost-effective way of handling straightforward RTA PI claims, and to ensure that more compensation reaches claimants quickly and to reduce the legal cost of these claims. In practice, the primary goals were to speed up claims value between £1,000 and £10,000, reduce the costs, standardise claims handling with a fixed timetable and fixed stages, and it was designed to encourage early admissions of liability, as without this, the insurers wouldn't get the benefits of the portal and reduce costs, and encourage the early exchange of medical evidence.
Okay, so in theory that works. How did it actually work in practice?
Right, so it broke claims down into 3 clear stages. So we had stage 1. This involved submitting what we called a claim notification form, or CNF, via the portal, with the compensator receiving that and having 3 weeks to respond to it. Stage 2 focused on medical evidence gathering and negotiation. And then stage 3 was for cases where an agreement on damages couldn't be reached. Essentially, it would go to a quantum only or disposal hearing, since liability was already admitted. The scope was quite specific, so we were talking RTA PI claims in England and Wales, damages between £1,000 and £10,000, where liability is admitted from the outset, and it did exclude some types of claims, so fatalities where we had allegations of fraud, and more complex cases, perhaps involving multiple vehicles where liability might be split across multiple parties, would come out of that system too.
Okay, so did that come with fixed costs?
Yeah, it did. So this was central to the structure of the portal. We would have stage 1 costs. That was an initial £400. So that would be paid by the compensator to the claimant law firm on admission of liability. And stage 2 fees of £800 paid on conclusion of the claim. These were later reduced quite significantly in the 2013 reform of the portal, where it'd be £200 and £300 for stage 1 and 2. Respectively, and also stage 1 at that point would not be paid until the evidence was submitted in stage 2, so it was paid at a later stage. At stage 3, these costs didn't change in the 2013 reform, but it would be £250 or £500 depending on if it was a paper hearing or an oral hearing, so there'd be an additional fee for the representation there. At this stage, you could still, at the 2010 stage, you could still recover the success fee of 12.5% as well. So a lot of cases you would find you'd have the £1,200 and that would be uplifted to £1,350 plus VAT as a sort of a net profit cost for the law firm dealing.
Okay, and how did the market react to these changes initially?
So this was quite well received from stakeholders on sort of both sides of the equation here. We saw faster settlement times where liability was admitted promptly, predictable costs for insurers in these cases, and significant improvements in evidence exchange. However, initially some insurers were perhaps slow to adapt to the deadlines, which resulted in a lot of cases simply dropping out of that system and being dealt with in the old regime. And I think it's fair to say as well that initially claimant firms were quicker to adapt, finding ways to get those cases to be removed from that system as well.
Okay, so you said generally positive there. Were there any particularly concerning market developments following this first reform?
Yeah, so perhaps the biggest of the problems that it caused was we saw a significant increase in pre-med offers or pre-medical offers. So this is the term we gave to cases where an offer is made and accepted before any medical evidence is received whatsoever. So in 2012, a consultation revealed that it could be as much as 25% of cases within this portal were settling in this way. So it did raise some serious concerns about fairness for claimants who might not fully understand the extent of their injuries and how much compensation they would be entitled to.
Okay. So clearly the portal seems to be working there, at least in terms of its stated objectives. What came next?
So in the next big reform was in 2013. It was a pivotal year. So following the like you said, the relative success of this portal, the government extended that portal to employees' liability and public liability claims through the extension, and created new protocols for those types of cases and updated the RTA protocol as well. A civil procedure rule update also introduced fixed recoverable costs extending to litigated cases. But much more significantly than both of those, we had the, as mentioned in the run through at the start, the Legal Aid Sentencing and Punishment of Offenders Act 2012, or LASPO. This came into force, which fundamentally changed the funding and cost landscape.
Okay, so let's break down that portal extension first. How did that work?
So this went live 31st of July 2013. I remember it well. It extended to include EL and PL claims, which we're not going to go into, but it extended the scope of the portal from £10,000 to £25,000. It basically mirrored the original portal with the three-stage structure. EL and PL cases, they had a longer time to, insurers had a longer time to respond to those, 30 working days for EL and 40 working days for PL cases, rather than the 15 you got in road traffic cases.
Okay. Tell me a little bit more about the fixed recoverable costs that came with this.
Sure. So concurrent to the portal extension, there was a system of fixed recoverable costs for injury claims valued up to £25,000. There were some exceptions where it might go over, which were later introduced through case law that I'm not going to get into. But this formed part of the Jackson reforms and was implemented for amendments to the civil procedure rules. It effectively replaced the predictive pre-litigation costs introduced in 2003 for a lot of cases, and post-litigation, instead of costs being assessed on an hourly rate, recoverable fees were set at fixed stages of the litigation process, such as post-issue, pre-allocation, and then once it had been listed, and then there was fixed cost as well for advocacy fees. This significantly changed the economics of running RTA PI claims. It encouraged efficiency. Overall, though, it did reduce the recoverable costs for claimant law firms.
Okay, thank you. Circling back, you mentioned that the really significant changes came from LASPO, didn't they?
Yeah, so this was just before that. In April 2013, LASPO came into effect and brought what I would consider to be game-changing funding reforms. So success fees, recoverable success fees were gone. You couldn't get these off the compensator at the end of your case. Claimants would now have to pay a success fee from their damages if they'd entered into that type of agreement. These were capped at 25% of general damages and any past losses. The after-the-event insurance premiums as well. So these were no longer recoverable from compensators at the end of cases, except in very limited cases, which we're not going to get into because they don't involve RTAs. Perhaps most importantly, there was a complete ban on referral fees in injury claims. So, insurers, garages, brokers, claims management companies were all prohibited from selling claimants' details following an incident.
Okay, so some quite big changes there. Is there anything else that LASPO introduced?
So it did introduce, to try and offset some of the measures against the claimant side of the reforms, it introduced qualified one-way cost shifting for most PI claims, meaning that unsuccessful claimants were generally not liable for defendants' costs unless certain exceptions applied. This provided some protection against adverse costs orders and reduced the cost of litigation funding, and therefore reducing the impact on the claimants of the changes of the recoverability to ATE premiums.
Okay, thank you. So looking back again at the big picture, what would you say was the immediate impact of these 2013 reforms?
Okay, so this is the first point that saw you when you saw some real market shifts. So at this stage, many law firms began to reduce their personal injury focus or shift mainly to the higher value cases. There was a dramatic revenue shift as claimant solicitors had to recover the success fees and ATE costs from the claimant damages rather than the compensator. It did reduce profitability, especially for low value work. And the fixed fees for the RTA portal claims were slashed by around 60%. So your complete stage 2 settlement fee would drop from around £1,200 to £500. so with the fixed recoverable costs coming in for the post-litigation work as well, you would see a lot of claimant firms making strides in efficiency. So that's one thing that came out of it. The referral fee ban led to some insurers as well to set up alternative business structures. So they're no longer selling claims details onto law firms. They would set up law firms and effectively keep that work in-house and offset the loss from that referral fee income. They did succeed in cutting the cost of claims, so around 30% from its peak, total cost cutting for insurers at that point.
Okay, good. As a result of all this, though, were there any unforeseen consequences?
Well, so not necessarily unforeseen, but many injured parties were having to forgo large parts of their damages. It did squeeze a lot of claimant law firms. You had lower fixed fees, non-recoverable success fees. It could make the low value work uneconomical to run. A lot of firms couldn't make the shift to a more efficient way of working and moved out of the sector. A lot of claimant-focused firms had a model prior to this where referral fees essentially were paid in lieu of a marketing budget. And it was very difficult to make that shift. So some found it incredibly difficult to keep acquiring work in the volumes that they were before.
Okay. So looking ahead then after LASPO, where did the focus of the reform shift to next?
So after that, attention shifted towards the quality of medical evidence. So we had we had anti-fraud measures, particularly concerning whiplash claims. So we had two developments. There was the Criminal Justice and Courts Act 2015, which allowed fundamentally dishonest claims to be struck out entirely, even if there was a legitimate injury or part of the claim was legitimate alongside an exaggeration. This also meant they would lose their quox protection, which, as we mentioned, the cost shifting meant that in most cases when a claimant lost, they wouldn't be liable for a defendant's costs. In one of those scenarios, then they would case be struck out and they'd be liable for the defendant's costs. And then we had the introduction of Medco.
Okay, so you mentioned Medco there. Can you explain what Medco was designed to achieve?
It was a government-endorsed portal established in May 2015 specifically to source medical reports for soft tissue injuries. So under this system, claimants or their solicitors were required to obtain medical evidence from an accredited medico-legal expert allocated via a centralized portal. The key point was random allocation, so it prevented claimants from hand-picking doctors they thought might provide them with more favourable reports. It was intended to increase consistency and scrutiny of medical reports in soft tissue cases and curb what was termed diagnosis inflation, and so was considered to be a step towards discouraging fraudulent or exaggerated whiplash claims.
Okay, so that's quite a change there, isn't it? So did Medco have the desired impact on claim volumes?
Despite the early reforms and a reduction in numbers that we'd already started to see at this point, the numbers remained quite high. So you're talking over 770,000 motor claims in 2015-16. So insurance industry advocates continue to highlight a whiplash epidemic. It was and considered it to be a key cost driver for premiums. So whilst previous reforms had reduced some legal costs, they hadn't drastically cut claims numbers. However, Medco, specifically targeting soft tissue injuries for occupants of a motor vehicle, perhaps set the stage for more radical changes, specifically targeting whiplash injuries. Another change worth mentioning prior to Medco is the fixed cost disbursement changes, which came to the civil procedure rules in October 2014, so slightly before Medco, which limited the recoverable fees for GP medical reports alongside of some other types of medical reports. So this, again, was a measure to reduce fees, which went alongside the allocation of random allocation of medical experts. This perhaps did lead to some of the larger players in the medical reporting industry increasing their market share and smaller agencies falling away.
Okay, perfect, thank you.
Right, so now we're getting on to the big stuff, the official injury claims portal. So before Martin asks me any more questions, I'm just going to quickly mention the Chancellor's Autumn Statement in 2015. So George Osborne announced his intention to introduce measures to tackle insurance premiums, citing whiplash claims as the driver for high premiums. There was still a lot of noise around compensation culture or a whiplash epidemic at this stage. Even though that was still there, the statement came somewhat out of the blue. I've gone back and I've checked the 2015 Conservative Manifesto, and I can't find any reference to whiplash, injury compensation, or compensation culture. However, at the time, anybody in the industry at that point will be aware that there was some quite intense lobbying of the government by the insurance industry, which may have impacted the direction that the government chose to take at this point.
Okay, thank you, Nick. And like you say, brings us on to the big stuff now, the Civil Liability Act. So can you explain what this was trying to achieve?
Yeah, so Civil Liability Act 2018, it was a package designed specifically for whiplash claims. It represented a fundamental shift from a common law valuation of injuries to a statutory tariff approach. The Act empowered the Lord Chancellor to define a whiplash injury, establish a statutory tariff of damages for whiplash injuries that lasted up to 2 years, and permit a judicial uplift of up to 20% in genuinely exceptional cases. So I've put a definition of whiplash injury up there on the screen, but essentially they defined whiplash injuries as meaning a soft tissue injury to the neck, back or shoulder, such as a sprain, strain, tear or similar damage sustained in a road traffic accident involving a motor vehicle other than a motorcycle, but excluding soft tissue injuries connected to other non-whiplash injuries. Just to confirm the definition of motor vehicle, in the Road Traffic Act 1988, it's defined as any mechanically propelled vehicle intended or adapted for use on roads. So this perhaps was not drafted as intended. The Civil Liability Act 2018 specifically excludes motorcycles, but technically that definition of motor vehicle, which seems to mirror the equivalent EU directive, would technically include things like pedelecs and mobility scooters, although in practice I've never seen it argued that the tariff system should apply to those types of vehicles.
Okay, and alongside this, there was also a major change to the small claims track, wasn't there?
Yeah, big. So the small claims track for RTA PI claims increased dramatically from £1,000, which was the small claims limit for all injury claims, to £5,000, effective from 31st of May 2021, which is when the Civil Liability Act came into force. This meant that anyone suffering a whiplash injury or minor injury in a road traffic act that fell below £5,000 would no longer be able to recover their costs from the at-fault party. To support this, they brought in the RTA small claims protocol, and a new practice direction was introduced. The practice direction covered the bespoke paths for litigation within the official injury claims portal. Other claims had the small claims limit increased to £1,500 for other personal injury claims. However, in road traffic claims, the claims that were excluded from that £5,000 limit, such as vulnerable road users, retain that £1,000 limit. So there's a list of specific road users, which we'll go over later, which is covered in the amended practice direction. So now we've gone from a position where we've got a £1,000 limit for small claims limit for injury claims to 3 separate small claims limits for injury claims.
Okay, and what was the government hoping to achieve with these reforms?
So clamp down on exaggerated and fraudulent whiplash claims through fixed compensation, reduce claims costs, to lower insurance premiums for motorists, and they hope to develop a portal to efficiently handle these low value claims and allow claimants to manage their claims themselves. They were hoping to balance fairness with efficiency.
Okay, and do you think that the market started feeling the effects before the implementation?
Possibly. So even in anticipation, claims management companies and lawyers were adjusting their business models. The Compensation Recovery Unit recorded a 15% drop in motor claims the year after the Chancellor's Autumn Statement, and we did see some listed firms that I won't name, see a sudden drop in value after that autumn statement. But there are other factors, and of course there was a continued effect from the previous reforms. And then prior to the implementation of the official injury claims portal, of course, we had the pandemic, which reduced road traffic accident numbers generally, and of course with that injury claims.
Okay, so that brings us on then to the official injury claims portal, which you just mentioned, the OIC. This was positioned as allowing people to handle claims themselves, wasn't it?
That was the intention. It went live 31st of May 2021, and it was marketed as a free online service for low value RTA PI claims, and the scope was of injury claims valued under £5,000, but where the total claim was valued under £10,000. It was built by the MIB, the Motor Insurers Bureau, and its core purpose was to allow claimants to run claims with or without legal representation.
Okay, so how does the OIC portal actually work?
So it's not dissimilar to the previous portal, where the injured party would submit an online form to the compensator, who would then respond. There were some key differences though. So firstly, if the compensator didn't respond in the time limit, they would automatically forfeit liability, although it wouldn't be binding. This is a key difference. It wouldn't be binding on other claims relating to the same incident. Secondly, the scope extended beyond where liability was admitted, so insurers could dispute in full, make offers on liability, and then there was a specific litigation process to deal with the issue of liability prior to the issue of quantum being dealt with. Our experience on this, though, is that where liability is disputed, either in part or in full, insurers will frequently try and circumvent the rules on evidence for liability, often attempting to introduce late evidence contrary to the rules. And for an individual bringing a claim on their own, you can see how this could present a challenge and how they could easily be disadvantaged by this.
Okay. And am I right in thinking that there's publicly available usage data from the OIC portal?
Yeah, there is.
Okay, so what does that usage data tell us about how the OIC has performed?
It's quite revealing. So if we go to the first year, year one, when it was introduced, so 31st of May 21 to 30th of May 22, we had around 255,000 claims started in the OIC. Interestingly, 91% represented, while only 9% were unrepresented. So challenges the initial expectation of a DIY system for people to bring their own claims. And having said this, though, unrepresented claims actually settle faster. So we're looking at 80 to 85 days compared to 141 to 172 days was the scope for represented claims. But requests for the exceptional uplift of 20%, where your injuries were particularly bad, were more common along with unrepresented claimants. So you're looking at 32% of them as opposed to 20% for the represented claimants at this point.
Okay, so you mentioned there that that's the data for year one.
Mm-hmm.
What about more recent data?
So I've put up there the data for the last quarter and the quarter before, so you can see the split between represented and unrepresented claimants doesn't seem to have changed too much recently. So the last quarterly data from April to June shows there were around 60,000 claims, and we had 88% were represented, 12% unrepresented. Since launch, we've had over 1 million claims, and I should say 79% of those were either admitted in full or partially by the insurers. What's interesting, though, when you really drill down to the data, is how the different groups go to court. So with represented claimants, around 20% of them go to court within the system. Whereas with the unrepresented claimants, only about 4% go to court, which is a significant difference. So I think the best way to illustrate this is if we take the last quarter, you've got 60,000 claims. So assuming 53,000 of those are represented and 7,000 unrepresented, you've got around 10 to 11,000 represented claimants pursuing a court action compared to only around 350 unrepresented claimants, so around 30 times more likely to be litigated. 30 times more claims are litigated if you're represented. So And then if we look at settlement sums, the data's quite interesting. The data reports very similar sums for represented and unrepresented claimants, but this data, interestingly, doesn't include cases which are litigated to dispute quantum. I did make a Freedom of Information request to the Ministry of Justice for this, which I received back today, and they told me that the data is held by the courts and is for court purposes only, and they're not going to provide it to me. But I strongly suspect that those figures will skew more in favour of represented claimants in terms of the damages received when you start adding in the level of damages once the matter has gone to court.
Okay, so what would you say has been the overall impact on claims volumes?
The impact's been profound, really. So the OIC and whiplash reforms coincided with a sharp fall in claims volumes in 21-22. So the total number of claims dropped to about 390,000, down from 650,000 just 2 years prior. So we couldn't have that COVID year. But by 24-25, we hit an all-time low since that peak of 312,000 claims. So insurers are attributing this to removing financial incentives for small claims and the deterrent effect of requiring medical evidence for lower damages, despite the insurers having made all those pre-medical offers themselves in the first instance. However, consumer advocates will point out that many genuinely injured people may now simply forgo claiming because the process is too much hassle for a relatively low payout.
Okay, thank you. So looking at a different area then, one area that's sort of created significant legal complexity is mixed injury cases. Can you explain what this means and why it's been problematic?
Yeah, so this refers to cases where a claimant has both a tariff and another non-tariff injury from the same accident. So the challenge was how to value these cases. Do you apply the tariff, the common law valuation, or some combination? So really it arose because you've got two opposing sides here. So I'll give you one scenario where you've got say a 6-month whiplash injury and perhaps a 3-month thumb injury. So your 3-month thumb injury may be worth £2,000, whereas your 6-month neck injury, based on today's tariff figures, which I've got here, would be £495. So the insurers would look at this and say, well, comparatively, the neck injury is more serious, so why should we be paying more than that? Whereas on the other side of it, a claimant representative would be saying, well, no, they're perfectly entitled to their common law damages and their statutory tariff amount as well. It's a fixed sum. So you can see where the dispute came in. So the matter became so complex that it required litigation right up to the Supreme Court for clarification on the issue.
Okay, so you've mentioned the Supreme Court there. How did they resolve this?
So the decision in the case of Rabo v. Hassam in March 2024 laid out a very clear structured sequence. So firstly, assessed the whiplash tariff under the 2021 whiplash regulations. Secondly, assessed the common law damages using the Judicial College guidelines for the non-whiplash type injuries using your traditional principles. And then third, add the two figures together. Then what you would do is you would take a step back and consider a saddler, which I'll explain in a moment, a saddler type adjustment to avoid double recovery, usually making a reduction, and any deduction must come from the common law element, not the statutory tariff. And then crucially, they said that the final award must never be lower than what would be awarded for the non-tariff injuries alone. So in that situation I described before, where you've got a 6-month neck injury of 495 and you've got a thumb injury of around £2,000, you're not getting less than you would get for that thumb injury. So you'd probably get around £2,000, maybe a slightly more. Going back to explain the saddler approach, that's how we would look at multiple areas of injury being valued under the Judicial College guidelines, where you would have a sort of a bracket for injuries. So what you would do is the way I'd like to describe it to clients is you look at all the individual parts, and then you take a step back and assess whether the overall effect is less or more than the sum of the individual parts. So usually you'd look at what would be considered to be the primary injury, and then add on a heavily discounted amount for each other individual injury to come up with the final amount.
Okay, so can you explain why this structured sequence is so important?
Yeah, so you can see the portal came in 2021, and it took to 2024 to resolve this issue. So it was quite important. So it ensures that the statutory tariff is respected, while non-tariff injuries are valued at common law. So the step back approach prevents an overlapping compensation, but with a crucial safeguard that claimants aren't disadvantaged having mixed injuries. So it provides much needed clarity on what had become a confusing area.
Okay, so we're getting quite recent now. So the most recent major development has been the expansion of fixed recoverable costs in 2023. What changed there?
Yeah, so there was a second Jackson report that was published in 2017, proposing further extensions to fixed costs. So these came in on the 1st of October 2023. And the fixed cost regime was extended across a lot of areas of civil litigation in the fast track, and then they created a brand new intermediate track for cases that were between £25,000 and £100,000, designed for simpler cases with damages up to £100,000. With both tracks, there are 4 complexity bands, which are detailed in a revised practice direction. There were specific transitional rules for injury claims. So in non-injury claims, the new fixed recoverable cost regime would be applied from date of issue. So any claim issued after that 1st of October 2023, those bands would apply. For injury claims, it was on date of incident. So you could have an incident that was before 1st of October 2023, but litigated afterwards, and you would still deal with cost upon whatever regime was in force at the time of the incident.
Okay, so how does that work in practice then?
So costs are determined by, like I said, complexity bands. So you would have for the fast track, so from the small claims limit up to £25,000, you'd have bands 1 to 4, and the intermediate track, £25,000 up to £100,000, again, bands 1 to 4, splitting cases by complexity. You had judicial discretion to move complex cases to the multi-track, which would normally be reserved for cases over £100,000, previously £25,000, where costs would be determined based upon an hourly rate.
Okay, so what does that mean for RTA claims specifically?
So most claims falling outside of the small claims track or OIC sit within fixed costs, whether fast track or intermediate track. You'd get obviously those higher value ones that fall above that. So costs are therefore determined upon how far the case progresses down fixed stages, not necessarily the amount of work that's been done. So case strategy then has to be heavily influenced based upon the complexity banding you fall into and the amount of costs that are going to be available for you to do that work. So most or all RTA personal injury claims would fall into complexity bands 1 and 2 of either the fast track or the intermediate track, which I've put up there on the screen, the various complexity bands. It essentially completes a long trend towards tariffing for both damages and costs across a broader spectrum of personal injury claims, and ensuring greater predictability and proportionality in litigation expenses.
Okay, so after walking through all these reforms then, where does that leave us today? You mentioned at the start that it's become a bit of a procedural minefield. Can you explain what you meant by that?
We've got a highly fragmented landscape with multiple portals, protocols, distinct damages regimes, all operating in parallel. So I mean, let me break down where a specific case might live. We've got the OIC, where you've got an RTA PI claim where injuries are less than 5,000 or the total value is less than 10,000. But to add complexity to that, this doesn't include vehicle or hire damages, what we call non-protocol vehicle expenses. So this creates an odd situation where you could have a high value vehicle, for example, that's been in an incident and there's more than £10,000 worth of damage to this vehicle. If you recover the cost of that and it requires litigation, you're going to be able to recover legal fees for doing so. But if you then claim for injury and your injury is a minor PI, because those non-protocol vehicle costs are taken out of that equation, you've then created a situation where you can't recover your legal costs. Then you've got the old portal of 2010, then updated in 2013, claims portal for any claims, PI claims that fall outside the scope of the OIC. But within those protocols where liability is admitted. And then outside those portals, they would follow the old general personal injury pre-action protocol and get allocated to the fast track, intermediate track or multi-track, possibly with fixed recoverable costs.
Now, am I right in thinking that on top of all of that, there's different rules for different types of claimants as well?
Yeah, so the occupant of a motor vehicle, if they're subject to the £5,000 small claims limit, as previously mentioned, but minors, protected parties and vulnerable road users, so cyclists, motorcyclists, pedestrians, horse riders, mobility scooter users, they retain that £1,000 limit, and they would all start in the old portal.
Okay, so what about the different litigation routes that are available as well?
Yeah, so you've got multiple options. So for all the cases that come outside of those protocols, you've got the standard money claim or Part 7 of the civil procedure rules is where they would start. So that's your traditional money claims, which would then be allocated to one of the 4 tracks at court that we've spoken about. So small claims track, fast track, intermediate track, multi-track. Some of those apply to a complexity band. And then you've got the old portal, the 2013 portal, stage 3, quantum only hearings, where liability is admitted within that process. And then you've got the specific litigation routes for the OIC. So there's various forms and processes for different issues within the OIC. I think there's 4 separate litigation paths you can go down within the OIC. On top of all those, though, as well, are for infants and protected parties. Even if the whole case is done and dusted without the need for litigation, you would still need to litigate to gain court approval of those damages because of their special status. So as you can see, you've got lots of different routes to litigate various cases.
So presumably with all those different routes, there's different damage regimes that apply depending on which route you take?
Yeah, so again, to wrap that up, it's another area of complexity. You've got, like as we said, the statutory tariff for whiplash injuries lasting less than 2 years with limited potential for 20% uplift in exceptional circumstances. Common law assessment for non-tariff injuries using the Judicial College guidelines. Mixed injuries applying the Supreme Court's Rabo versus Hassam sequence, so a complex process of assessment, addition and adjustment. And within that as well, there's odd situations where the small claims limit would still be that original £1,000, but we would then, and we start in the old portal, but the tariff could still apply. So minors, for example, who are occupants of motor vehicles, you start in the old portal, you've still got the small low claims limit, but the whiplash tariff applies.
Okay, so how do the costs work across these different systems then?
So for most OIC scope cases, these are would be considered small claims, very limited costs. So you're talking very limited disbursements and perhaps a small claims fee for it. For the non-small claims PI cases, fixed recoverable costs apply to the fast intermediate tracks with those complexity bands that we discussed, dictated by recoverable phases. Of course, you've got those old portal costs, and there's still some cases where the old fixed recoverable costs apply because, of course, the rules don't apply retrospectively. Those new 1st of October 2023 recoverable costs, and as a result of this as well, you've even got some cases which never fell into that initial new protocol where the old predictive regime and hourly rates could apply. So cases prior to that 1st of October 23 involving where if someone's involved in an incident with a foreign registered vehicle, they would fall out of those altogether, and you're back in the 2003 regime.
Okay, so I mean, all that sounds incredibly complex for somebody without any legal training. So how realistic is it that ordinary people are able to navigate this system?
It's an important question. We've already gone over a lot of the complexities of the OIC, but even if we assume it can be navigated without representation, what if the matter comes out of the OIC? What if the value changes, for example, if injuries are worse than they first appear or don't heal as expected? As a firm, I know that we would be reluctant to take on a case which has been partially progressed by a claimant directly, because of increase in risk for us. So unrepresented claimants, they've got to choose the correct gateway based upon claim value and any exclusions that might apply. They need to select the right court route if they want to go down that avenue. They need to understand the different methods of calculating damages, and they need to be able to comply with evidence controls like sourcing medical evidence via Medco, or drafting and submitting witness statements. If they want to dispute a case to court as well, then they need to consider how they're going to fund that. There's court fees to pay. The OIC service was designed for what we call litigants in person, individuals bringing their own claims. But its user guide, that runs to over 60 pages long. The sheer number of decision points, valuation nuances, rules and evidence, make professional guidance, I would say, incredibly helpful, if not essential, if you want to ensure you're getting a fair outcome. The playing field, I don't think is level. You've got unrepresented individuals facing an insurer with experienced claims handlers to manage their cases, and then they've got specialist law firms at their disposal to manage disputes as well.
Okay, so what can people do then to essentially avoid having to represent themselves?
The first thing I would say is making sure you've got adequate legal cover. Some firms will take these cases on, but you can expect that to be on a contingency where you give up 25% of your damages as legal fees, and you'll often be required to take out an after the event insurance policy too, which can be over £100 and will be coming off your damages at the end of the case. Or you might have to fund your own disbursements, including court fees. The other issue is that if court is required, there may not be funding in place for advocacy. So generally speaking, paid representation isn't recoverable as part of a small claim. We're seeing advocate fees of around £250 to £300 for these types of cases, which really makes it uneconomical to pursue anything other than whiplash cases, which are towards the more serious end of the scale. So even if you have legal cover, many policies explicitly exclude injury claims that fall below the small claims limit, leaving claimants in exactly the same situation as if they had no cover at all.
Well, thankfully, our policy covers all the costs then to pursue any injury claims for RTAs.
Yeah, it does. We've got an in-house law firm. We will deal with the whole case within the same team, including if people want the vehicle aspects of the claim. So what we find is that eliminates the communication issues and delays which can arise when those elements are split apart. The policy also covers court fees. We cover upfront disbursements for the clients, including the advocacy fee, which is then covered even if it's not recovered at court.
Okay, perfect. So before we wrap up then, sort of coming towards the close, what would you say is on the horizon? Are there any further reforms coming?
No, I don't think. No major reforms planned that I'm aware of. There are several areas of ongoing development. Tariff damages are subject to 3-year reviews and fixed recoverable costs, and the tariff figures were uprated in line with Consumer Price Index in May, and we don't expect, therefore, another increase in those for a while. We've recently seen the cost of fixed medical reports go up too, so we can expect those to remain steady for a while as well. We have seen the courts roll out compulsory mediation for many types of claims. The pilot was extended to road traffic accident claims recently. It does exclude injury claims. The idea is to clear court backlogs by encouraging alternative dispute resolution. So if the data from the pilot turns out to be positive, it wouldn't be a surprise to see this being rolled out to personal injury claims in the future. Lastly, the OIC, this is regularly reviewed by the OIC advisory group, which is made up of various stakeholders. They published the minutes online, and so far the changes have really been tweaks around the edges, improvements with data gathering and functionality of the website. So nothing major, but we will we'll keep monitoring the space and report on any major reforms that come.
Okay, perfect. So let's wrap up then with your key takeaways then. What, for insurance brokers and their clients, what are the important points to understand?
So RTA PI claims have been reformed multiple times in different ways over the last 15 years. The system has become far more intricate and challenging. What used to be a relatively straightforward system now demands navigating multiple portals, protocols, often much lower levels of damages for minor injuries. So for anyone coming into the industry over the last sort of 10 years or so, it can be quite daunting and difficult to understand why the system operates as it does. So hopefully this webinar has gone some way to helping people realize how we've got to where we are. While the reforms have succeeded in reducing claims numbers and insurance outlays, we've gone from over 800,000 claims a year at its peak to just over 300,000 currently. So I believe they've tilted the scales against the average accident victim. To dramatic fall in claims, whilst overall accident numbers haven't shifted greatly, suggests that there are a lot of injured people out there who are simply deterred by the complexity in bringing a claim or the lack of support available. The offsets, such as general increase in damages to offset that removal of recoverable success fees, or one-way cost shifting, they don't go anywhere near, I don't think, to offsetting the challenges that have been added to claimants.
Okay, so what would your recommendation be for insurance brokers?
Know how to save your client's interests. So this is where having a comprehensive motor legal expense insurance policy becomes very important. So a good policy doesn't exclude legal support for small injury claims, and even those under £5,000 where costs aren't recoverable. And I would say even for commercial clients, you're best served by ensuring your team members are getting the proper support that they need if they're out on the road and have an accident. Having the right cover means that you have funding for an expert to deal with the case for you, meaning sure you're getting fair compensation and you don't have to give away a chunk of your claim as damages or as a additional insurance premium.
Okay, perfect. Thank you. So just before we finish then, sort of any final thoughts from what we've gone through today?
Just that the system, it's largely achieved its stated objectives in reducing claim numbers and controlling costs. I'm not convinced on the fraud aspect of it that it was as widespread as considered beforehand. However, all the change on top of additional changes created an incoherent system, which I think deters legitimate claimants. So for those in the insurance industry, understanding the evolution and ensuring clients have additional protection is good business, and I think it's important for maintaining public confidence in the insurance system's ability to provide meaningful protection when people really need it the most. Okay, perfect. Well, thank you for all that. It's been very insightful, Nick. We will go see if anybody's got any questions that haven't been answered as part of the webinar. Otherwise, we will wrap up. I don't think there's anything come through just yet, but if you have got any questions, please feel free to pop them in the chat. If you think of any questions after today's session, you go away and you have a think about what's been discussed, please feel free to get in touch. We'll be more than happy to answer those. Also, for anybody that hasn't watched one of our webinars before, we'll shortly follow up with an email, so you get to watch this again. You get a copy of the recording and all the slides, so that if you have missed anything or if you haven't taken any notes, and don't worry, you can still revisit everything that we've discussed today. I don't think there's any questions coming through, so we will wrap that up there then. Just a sort of heads up ahead to next month, October's webinar is going to be on the Employment Rights Bill, so we'll be sending some further information out on that soon. Thank you all again for joining us, and thanks again to Nick for being our guest speaker today, and hopefully we'll see you next month.